Testing. Is it working? Not working. Working, right? Alright, just give us a minute more and then we will be starting soon. I've been friendly advice from my good friend in the audience that I must finish before 4:40 because there's a big event out there which I fully agree. Our friends are talking as well. So just in case you have questions, please go to the Slido and then take the point and then. But frankly, I want this session to be very interactive, so feel free to ask questions along the way because we really have, I think, less than 40 minutes. Okay, can we start? All right, let's start. Hi, everyone. I'm Xiong Kun, and this is woman, right?
Yes. He doesn't even know his fellow panelists. Okay.
Yeah, as you can see, we're quite interactive. Yeah. Now, we just want it to be as close as possible because today we're just talking about AI, but really it's the human together with AI because mediation is about human beings, about human affairs, right? But technology is something that we want to leverage on. So I'm Xiong Kun. I used to be a general counsel for almost 30 plus years of my life. So I know what I think a lot of you are still going through it. And so this is one area which I feel that is very valuable for in-house counsel to learn, not only just from the AI perspective, but AI in a useful way of solving disputes through mediation, right? And Woman, you want to do some brief introduction?
Yeah, I'm the human face to this whole talk. So there is a human part in it. It's not just all AI. So this is the intelligent part. You'll hear the artificial part from me, right? I'm a practitioner, disputes practitioner. I've done nothing else in my life. Probably don't know anything else, including AI. And I've been there for quite a long time. In fact, I see in the audience some faces that look very familiar to me. So I shall not say anything more. I only do disputes, so that's how I naturally gravitated into mediation, which is an alternative form of dispute resolution.
Very good. And you can see a lot of what we see is unscripted, so it's very spontaneous. But the same thing, we will really want to help you understand how AI is being used in mediation, right? So again, for those who just come a bit later, you can use the Slido to key in your questions. And like I said earlier on, I want the session to be interactive. So if you really have a question, just raise your hand and then just shoot it up. So AI is something that SIMC tried last year, and we were very thankful that we were successful. The journey started because we were celebrating our 10th anniversary, and we wanted to do something different. And the amazing part was that last year was a year where Gen AI was really hot, right? And then we say, hey, we need to get our feet wet. And so that's what we actually did. I can say that we tried different forms of AI, and one of the lessons we learned is that we actually do not know what we were looking for. By the time we tried our third AI, we kind of figured out. And that's where we found its importance to have a credible and reliable consultant. And I have the consultant, the privilege of PwC, and the guy sitting right in front of me, just in case you need to talk to him later. But really, having the good consultant make a difference in selecting the appropriate AI. There are a lot of different kinds of AI out there, but you really need to know what you want. So finally, SIMC figure out what we want. We need to help the mediator be more efficient in handling the cases. So that's what we did. And so just a 2-minute short video to show you what our vision and aspiration was, and some of it has already happened, and I'll show you the actual process. So this is, the journey that we started, and now this is a video, just a quick look.
Hi everyone, welcome to Singapore International Mediation Centre. I am Maya, short for Mediation AI Assistant. I am here to provide AI support to you in your mediation. The world is getting increasingly complicated, and so are mediations and disputes. At SIMC, we harness the power of AI to innovate the practice of mediation. I will work alongside your mediators and parties to assist them in a number of ways. For example, I can summarize voluminous documents in minutes with reference tags, saving valuable time and resources. I can present key events and facts in timelines. and key relationships in graphic form. I can analyze general similarities and differences of parties' cases. I can assist mediators and parties to find common grounds and generate some possible solutions. I can help draft an initial settlement agreement for parties' consideration and refinement to expedite the mediation settlement. I can help streamline the entire mediation process and work with documentations in various languages. As generative AI improves, so will I. This is just the beginning. At SIMC, we are constantly on the lookout for best practices to bring world-class solutions to our clients. While I can increase efficiency, we still need the mediator to provide the human connection. Working together, we aim to provide the optimal synergy of AI and mediator to help parties to resolve their dispute. Embrace the future of mediation with SIMC, where technology and tradition converge.
Okay, that's the introduction to Maya. Maya stands for Mediation Artificial Intelligence Assistant. So that is our version of the AI that we use to help our mediator. Now, just in case for those who have forgot, the slider is there. Now, I just want to go through the sequence of a mediation so that you can see what has been happening when we use Maya. Now, you can see from the, let me just do a little bit. This is the actual day of the mediation. So we have 7 days before it. 7 days, we get the documentation, etc. 3.5 days, we have a pre-mediation kind of a session. And then the mediation itself, if there's a settlement, we have the settlement stage and then the post-settlement. So I want to go through each stage with the human being here so that we can get the real life experience. So the first stage is 7 days before mediation. Now this is where the parties to the dispute will give their documents. It can be bundle documents, case statements, it can be expert reports, it can be affidavits, lots of stuff. Now, question to Oman, as a mediator, what kind of documents do you expect and why do you need this kind of documents in your work as a mediator?
Okay, for the general counsel or in-house counsel sitting here, broadly speaking, there are two types of mediation that can come in. One is after litigation or arbitration has started, and the other one is pre your actual litigation process. So depending on which one you get in, if this is a mediation that's surfacing and coming to the mediation center after proceedings have started, you would see typically parties bundling up their pleadings, their affidavits if they are filed, their bundle of documents, which would mean effectively voluminous, right? Depending on the sort of dispute you have. But if you don't have that, and increasingly we have more of that, thanks to quite a successful campaign by the mediation centers here, you get pre-litigation or pre-arbitration mediation coming in. And really this concerns all of you in-house counsel because I think you have on your plate quite a lot of stuff. And if you can clear that without going through 2.5 years of litigation or arbitration, you'll want to do that if you can, provided you get a reasonably good settlement. So you have those kind of bundles that come in as well. But typically in those, of course, it's minus all the court documents or the arbitration documents. You would have the source-based documents, the agreements usually, most of these are commercial, agreements in question, and probably, as most cases are nowadays, correspondence which is usually by way of email. So a select part of that will come in as part of it, and you'll get the parties giving in summaries as well as chronology of events. Name of party and individuals, of course, is covered within the statement. But I'll pause there before I go to D and E. Maybe Xiongtun, you want to say something about it?
Yeah, so Oman, when you get these documents, have you got documents as many as like 10,000 pages?
Mediation, I have been fairly fortunate, maybe slightly less than 10,000.
Okay, so so let's say you have 10,000 pages, would you really read every single page?
That's what they pay me to do.
Okay.
So at least the parties that come before me truly believe that I've read everything.
That's an honest answer. The use of AI, Maya, or whichever AI that's suitable, will actually help to condense that. So for the 10,000 pages, we have a real chance to do it for about 6 expert reports. 10,000 pages, we managed to summarize in less than half an hour, right? And for Oman did one of the case with us, and I can't remember the number of pages for his, but we have a very good success rate. And what we are saying is that mediators who have used this, it helps them. But one key thing that we put in our basic principle in SIMC, that mediators are responsible for the whole mediation. They can rely it as an assistant, as a tool. By the end of the day, their professional duty requires them to go through the facts themselves. So it's the right answer. He has to read all the papers himself. And also, Maya can also give an accurate chronology of events. So imagine you have documents going back 10 years. With this Maya, it would help you define, but you have to be clear what you want them as what are major events. When you define the prompting in the language, then the good, accurate result will come out. And similarly for the table of parties and individuals, I think, is it helpful for you when you want to know who are the people in the cases, especially if you have like a few parties?
I mean, it definitely helps in multi-party sort of litigation or proceedings. But I just want to say something about this, which is in terms of chronology of events, etc. Now, it varies from mediator to mediator, arbitrator or judge. But as a general rule, I think if you have been in practice, and most of you, I'll take it, will have some sort of a legal basic background knowledge, you would know that what you would expect from a judge hearing your case or an arbitrator is to have read the documents, which is why it's given to you 7 days or 10 days or 2 weeks before. And what do we do? Now, this is the human angle. We actually plow through the documents. The smarter ones among them look first for the concise summary, which usually comes in the form of a statement of claim or opening statement, as we call it, and from there we condense and we read backwards, right? So in a sense, that's what the AI also will be doing. It's trained to do it. But what you have to bear in mind is this. For the old-fashioned guys like me, I tend to actually write down or type out as I read, okay, these are the name of parties or individuals. What are the key facts? Chronology. Chronology is very important. What really helps, take it from me, as a human mediator is, I have this sheet now that came for this last mediation, and what I was actually doing was, I was actually cross-checking. So now I've saved the time on typing. I have this sheet, but I must caution, what I'm doing is I'm cross-checking. I still go back to my old trained way, which is the way I would have done it, but instead of having to type out or write out, I'm now looking at it and saying, oh yeah, it's right. So I'm actually reassuring myself that the AI has got it right. No, you never know, because I'll tell something later on from my own experience of how it's still a work in progress.
Yeah, that's right. It's definitely a work in progress. We're all learning, and AI definitely will improve. But like I say, and later on I'll go into a slide to say how we put in certain guardrails to ensure some safety for the mediation at SIMC. So what about the D and E, table of similarity differences between the parties, common interests and possible potential option? Do you find it useful?
Okay, let me just tell you this. I'm probably sitting here because I'm I'm being very candid about it. I've told Weiming as well, and all the powers that be at SIMC. I definitely am one of the first guinea pigs they trialed it on. So oink oink to that. And if you look at it, I actually had different versions of the AI production sheet coming to me. So I'm telling you exactly blow for blow what happened just 4 weeks ago. I got a bundle and compilation of documents by email, which was sent by both parties' counsel to SIMC and sent to me. And then, that's what I usually get and I'll read it, right? But then I got along with it, this sheet. I was just telling the gentleman here that I actually ignored that sheet. Because this is the old-fashioned mediator. You know, he just believes his own eyes and his knowledge. I just ignored it. The next day, the registrar of SIMC resends this thing. And he says, Uman, ignore yesterday's email on this sheet. Look at this sheet. And that sort of, piqued my interest. I said, what on earth are they trying to send me now? No, I don't trust these things, when you send a second time, there's a mistake. SIMC not up to scratch, or the party's not up to scratch. So I actually went back home that night. As you know, we all work very late at night, practitioners. I sat and looked through the email. I looked at both documents. Oh, what's the difference? Everything looked the same because a lot of gibberish coming, machine operated sort of stuff coming out, right? And I went and looked back and forth. I realized for the first time, I truly was a guinea pig because they were giving me E. E is interest and possible options. The first sheet that came 4.5 weeks before didn't have options. Now, what are options? The AI was actually trying to tell Mr. Smart Mediator, with this problem you have, we think you can do A, or you can do B, or maybe you can suggest C or D. Oh, whoa, game changer. I looked at it and I said, we're trying to be smart, is it? Then I looked at it carefully, I said, started looking at it carefully, and I realized this is quite different, because I think what we had seen up to that point in time is standard A, B, C, and D. Now let me focus just one point on D though. D is very useful. Initially, I just ignored it, and let me tell you why it's useful. We have a limited time during mediation. It's unlike arbitration or litigation, right? We start at 9 or 10 o'clock at SIMC, very efficient use of resources. We have to pack up at 6, but we don't. SIMC will tell you that the hardworking mediators there will sit there until 4 a.m. This is legendary, but it's true. It's very true. But what do? We need to save time. Now, in order to save time, we need to narrow down the parties' positions. And that's where D becomes very useful. Now, again, this is a game changer. I never had it before. So now I started really looking at the document. For the first time, I started to trust some other form of intelligence other than myself.
Excellent. So you can see that there is some progress, and we will only get better over time, right? Now, the second stage is the pre-mediation. So what the mediator would do is to enter into a private session before the mediation to just get to know the different parties, build up relationship, and so on and so forth. And usually with the aid of the Maya, some of the summary or some of the table of similarity differences, it may be of use to them. Okay, so is there something that you want to comment on this? Okay, no. And then now we are onto the actual mediation day. Now this is interesting. Not every mediator uses Maya on the actual day. We only have we have got one case, and later I'll show you the code of that the mediator who uses it. It is very useful if you know, like I say, the mediator also needs to know what you want to look for and needs to know what Maya can do and has the limitation. So for those who know, like for example, they have read certain facts in the case and then look at the summary, they know it's somewhere there, but they couldn't figure out because they need that fact in order to relate to the party during the actual mediation. So they give the question to us, and thankfully she remembered the keywords, and we find the keywords and we go through the Maya and we came out and managed to grab and get the text of the documents and the actual document itself. Then it was useful in that sense, right? So this is something, yes.
So Maya is live during the mediation. So the mediator has a laptop with Maya plugged in.
Okay, at this stage, yes, thanks for the question. So Maya is live, real time,
yep.
But the person holding on to Maya on the laptop is one of our staff. So because the reason is that you need certain skill set, the prompting, and which is why PwC has the capability of training people to use a good prompting and stuff like that. So you need a skilled AI executive to handle Maya in order to handle the queries from the mediator. Yeah, but we do not know. Hopefully, in due course, when Uma decided to do something more study, he would go for training.
Obviously, they didn't deem me smart enough to operate Maya. So I can tell you right now, during my session, I didn't even know it existed. I thought it's something that they give to you and that's it, live with it. Right? Now that I know this, I'll quiz them further.
So after the mediation, if there is a settlement, one of the challenges we had, and Uma can share with it, understand that if there's a settlement, it takes time for the settlement agreement to be drafted. You want to share your experience?
I mean, honestly, this is the real fruit of your negotiation or your mediation. That's what you're aiming for. But what you find, honestly, is that in most cases, if you've been there live, you know that this is the thing parties are probably most ill prepared for. And the reason for that is, first of all, your patience is already worn down. If you have been sitting in that room for about 12 to 14 hours, I'm not kidding, that's exactly what happens, because commercial parties want to get the best deal if they're going to settle. So when they finally drum out some sort of a settlement, then someone starts saying settlement agreement. Now, typically the experienced counsel that follow parties, and you know that in mediation you don't need to come with lawyers, but most of them do nowadays. Experienced counsel will come with some sort of template, boilerplate clauses template. But there are some counsel who come, particularly when you're dealing with international mediations as they do in SIMC, where parties fly in themselves or come with in-house counsel and they don't have a template. Then you're at the mercy of the other side, so they come out and knock out the first draft. That's how it actually works. This is obviously going to be much more useful, because I think from a perspective of neutrality, if one party is not represented or does not have access to any boilerplate clauses or draft templates, they probably would trust a machine more than the other side's counsel, at least for the first draft.
Thanks, Suman. So what SMC can offer is that the heads of agreement is decided by the both parties with the help of the mediator. So we don't draft that. So that has to be done by the lawyers on both sides. What we give is a boilerplate, the recital, which is based on the summary of the cases, based on the case statement that is submitted by the warrant parties, and also the boilerplates, just the standard boilerplates. And then again, it's left to the counsel to draft it themselves.
Sorry,
Yes.
the boilerplate, does it include yet another dispute resolution clause, and what is it?
We normally put it to be enforceable in Singapore, because it's done.
So court-based enforcement,
Yeah,
not
court.
mediation again or anything, right?
No.
Okay, thank you.
You know, there's a choice of parties, right? It really depends on what you want.
Yeah.
So parties, you can have your escalation clause, which is, go for mediation first, and if it fails, then go arbitration or litigation. You can do all of that. But I mean, it's not uncommon. We have seen settlements breached, broken, and coming back again because one party or other has actually played through it. But it's really up to the parties what they want to do with it.
So the beauty of doing mediation at SIMC, based on our records to the best of knowledge, is that none of the parties have gone for enforcement. And it's not that, I almost want to say the wrong thing, but let me say it the other way. It's because the parties are open to discuss their issue before they sign. If they are not agreeable, they don't sign the agreement. So because they have decided to move on and they sign the document, and therefore they are able to get on with their differences and move on from there. So because of that, so it's not so much the legality of enforcement, but that so far we have encountered. It's more making sure that parties that come to mediation at SIMC, they are really open and they're willing to talk, and that's why we can have a successful settlement. Yes.
How do you deal with the confidentiality and privacy information here?
Very good question. Can I finish this part and I'll go into that, the part where I say there's a guardrail? So we have certain ways of putting it. Okay, so now this is our aspiration. We are not there yet. Our hope is that at the end of every mediation, we are able to have the Maya to compile the things that's learned and be able to produce some kind of a post-mortem analysis summary that we can do better. So we are not there yet, but this is one of the aspiration point. Okay, this is the final product that we see. So when Maya generate all those deliverables, we have to condense it, and then you have it in the table form. So this is just a cover page, right? Now, so this is the important part, which the safety that I mentioned. AI is wonderful, but it's like a fire, right? A fire can be a wonderful servant or can be a terrible master. If you don't control it, you have the wildfire in Sydney and Arizona and all these places. But if you control it, you keep your place warm, it fires up the engine and stuff like that. So one of the key things we wanted to, or the three key things is, we do not connect to the internet. Now, one of the reasons we realized that, you heard of this thing called hallucinations, right? We realized that if you keep control on the documentation, and you don't link it to the outside world, then you have cut down a lot of this kind of hallucinations. So we don't link to the internet, and I mentioned we only keep to the documents supplied by the parties. So if the parties give us documents that's incorrect, it is still within the parties themselves, right? And last but not least, we have this automatic deletion of data. So basically the machine doesn't keep track. And we are still going through the pilot phase, so we have not turned this off, as in it still keeps it, but once the pilot phase is over, the automatic deletion will be. So in essence, what happens in SIMC is that the information is confidential, is secure, and the hallucination is not there because it's not linked to the internet. Yes.
That means there's no auditability either.
Auditability of
Auditability.
what?
Documents that are white.
Right. If you go through the logic and then
Okay,
one wants to challenge.
So the machine itself has okay. It's basically we use more than one tool to form Maya. Maya is our name, but it's a third-party tool that we're using, and each of the third-party tool has their own audit with the various security ISO 2007, is it? And all those things that are in place. There's some safeguards there.
There's a log page.
Yeah. So it's something that is controlled by the third party, and we are making sure that as far as a review, summary, all those are done in a way that is acceptable.
So what is white is actually the documents of the clients.
Yes.
Is it? Okay.
Yes.
It doesn't save the documents uploaded, and also for auditability, it does pinpoint citation, so you can actually check the work as well.
Oh, okay. So it will have a citation, and the
Okay.
citation you
Oh, so
can
you mean
manually
yeah.
cross-check.
So basically the citation of the documents is there in terms of you have a summary, and then you're questioning that particular paragraph, and the paragraph that is a footnote. You click on the footnote and it drills you to the exact document, and then you can decide for yourself whether it's accurate or not. So if you're talking about the kind of auditability, yeah, the citation is there.
There's a question.
Yes.
If the data is only limited to the documents provided by parties, how does it generate options that are creative or innovative that is outside of the box?
A very good question. I will give my answer, and then Ari will give the more intelligent answer. Okay, my answer is, you want more creativity, you have to be linked to the internet. You want less creativity, and you use the machine that is trained, and the machine will continue to be trained with new and new materials, so that level of creativity is there. The question is that the creativity that you need, the bigger one with the internet, that's where the human element is very important. He has to decide which element give him that twist of the idea that he can use for the mediation case, and certain elements he has to reject. So that's why it's very important, and I say that to my colleagues, this machine can be additive in the sense that you like the result and you don't check. Then that's very dangerous. So complacency is a real danger. You must be professional and ethical. And that's why our mediators, we ensure that they understand this even when we share this technology with them. Yeah, Eric, you want to use the mic?
Yeah.
Hi. I think what Xiangkun has described is absolutely the right approach in reducing the risk of hallucination, which is you upload the document that becomes the context for the Gen AI solution. In terms of creativity of the machine itself, we're coming up with options. I think ultimately what it's really good at is, because it's a fine-tuned legal generative AI solution, it gives you sort of more comprehensively what it knows, which is in its training data point. And its training data point is a combination of case law, legal textbook, legal memos, contracts, legislation, etc., etc. That's meant to provide, to Xiangkun's point, a first draft. And ultimately, the intelligence in this whole equation is Mr. Uman, who actually will contextualize the artificial options to essentially what comes out from the mediation. So that is still required as part of the process, the human in the loop.
Thank you. I'm conscious I only got 4 minutes. Okay, so very quickly, I just want to share the real comments from 16 mediation that we have done, and these are all from experienced mediators. most of them are positive and constructive. I like the part that is on the top right hand corner. This is from I would just say from the King's Council. Very old school, and this person said, I will read it and oh, brave new world. You know. So what I want to encourage everyone is that regardless of where you are, is here. You have to use it, embrace it, and learn it, and you will only get better in your in-house practice, and especially for mediation. So it's useful too, but always need to be supplemented with hard-nosed judgment calls. So this is where the human mediator is required, and many parties involved, so the table individual is helpful. So it's really true. Summary, chronology, table individuals, this is universally true for almost everyone. Okay, this is the last one. He's not the only guinea pig. So we tried options on another senior mediator, and this is his comment. So he said the options suggested appear to be pro forma, not tailored to the circumstances of the mediation. However, it's a good start with potential to be a lot more useful. Yeah, so we are very encouraged because he's a very long time mediator and very familiar with technology. Yeah, so you can see that there are so many areas, and the one that I mentioned about the mediation ongoing. Oh, I think it's the earlier start. There was something that was done, and I will end soon. Oops. Yeah, this one. Yes, this one. A jury found a comparison the expert report to be helpful, especially second output generated in response to my specific question during the mediation. Pages blah 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 was this. So it does work. Okay. So in the interest of time, and I know I'm running short, any other questions that you have?
Will this be shared with the state courts where I volunteer?
My CEO will answer the question.
So thanks to all for joining us for this session. We are all part of this journey, right? I don't know how many of you have actually tried AI in your legal work. I know you do your Llama and your ChatGPT and all that. How many of you actually tried in your own legal work? Well, not. I think about half of us here. So how was the experience? Is it positive or yeah? I think generally it's positive. So it is part of our duty, I guess, to make sure that it is a tool that is used effectively and safely as lawyers, right? I mean, for us lawyers, safety is very, very important. The company look to us. So as part of what we're trying to do in Maya, is to see how this AI tool can be used for the benefit of improving mediation. Whether it can be used with state court, obviously I need to talk to Zikin and others, but we are very willing to share. And if you come to SIMC for your mediation, whether you are a mediator or as parties, you would actually get to experience it. And what we hope to see is what Seong Kun was saying, is that hopefully we will be able to generate options in an effective way. And I do recognize the limitations when you do not connect it to the internet, but you know, with all the learnings that's happening every day, we're actually quite impressed with some of the options that has come up. So I think that's the good thing. But within the safety of that platform of not connecting to the internet, we think that will only get better. Next year when you come back, we'll probably have a different report, and you can share with us of your own experience of how AI has helped your own work. But here in mediation, I believe we were the first organization, mediation center, to have used AI as part of our mediation. And the mediators, certainly the ones that we worked with, told us that it's been a very positive experience, and it's also their first time being helped. The other thing I want to add is that we would like our mediators to learn the actual tool of prompting and all of that skill. But for those of you who have tried, you know it's not easy. and the level of skill of the person who prompts will actually provide different results. So you can have a very good senior lawyer, maybe as far as AI skill is concerned, maybe a C, C plus as it comes to come out with the final product of the AI. But in the hands of probably some of the younger folks here, you know, you can probably do an A plus. So the question is, how do we generate that and really use and leverage the power of Maya for the good of the community, the legal community. Thank you.
One last question.
Yeah.
The SMC model of mediation is not for the mediator to suggest options. You know, it's for the parties to generate, etc., right? That's the principle. So are the options generated by Maya shared with the disputants?
No.
So it's only for the mediator.
So something we have thought of, and again, excuse us because we are all learning. One of the things that we've decided is that this is a tool to help the mediator, right? So the better the mediator is, the more the mediator is able to very efficiently conduct mediation, the better results will be. If you think about it, what women say, he has to read all the documents. That's what he's paid to do. But the difference is that when you have to retrieve something, when you have to think of something, when you try to remember something, it will be so much easier if you have Maya to help you to do that, right? Because we all have our limitations. So the roles, the individuals, the chronology, all that is beautifully done to help the mediator. And same for the options. It is really to help the mediator look at evaluate the expert opinion, etc. And the document is only passed to the mediator. It's handed to the mediator. So the idea is for the mediator to then decide how he or she wants to use it to the best of results. Okay?
Thank you.
Okay, for those who have more questions, you can stay behind because I understand it's 4:44 now, 4 minutes. The other session we have started. So feel free for those who want to stay behind. We are more than happy to answer whatever question you have. But thank you very much for attending. And if you haven't left your contact number with us, feel free to do so, or you can go to our website. Thank you very much. Have a good evening. Thank you. Now we have to take a photo. Thank you. Just according to him, he has done his research.